Hello, my name is Van Smith, managing partner here at Smith Strong Law Firm in Richmond, Virginia, serving across the Commonwealth of Virginia on family law matters. And today I wanted to talk to you about income imputation in Virginia support cases. Whether you're facing spousal support or child support, how do we factor income to set these support awards? Well, what is income imputation? So, imagine you have voluntarily stayed at home with the children, but you have a college degree and you previously worked. And you go to court and there's evidence that you had a reasonably successful job and then voluntarily quit, and you have these skills and educational background. And so can a court impute, that is, assign you income that you don't actually make? And the answer increasingly in Virginia is yes. As parties are now being equally educated, as we're seeing more people go through vocational schools or college education, it is what we see then is a higher level now than in past years of imputation of income. Virginia Code allows for this by taking into account what people of your education, work experience, age, and related geographic factors earn typically. And if you have no history and you have no substantive education beyond high school, then assigning the minimum wage, or I've seen also courts say, well, you could always get a job at an Amazon factory. What do they pay now? $20, $25 an hour. And so I have seen these imputations go along those lines, even for people with checkered or very minimal employment history. There's also involuntary employment status. So if you quit your job through fault, maybe you committed an error, or maybe you just outright quit your job to lower your income temporarily in a support award, the court will oftentimes see through that and say, well, look, it was either a for-cause firing or termination, or you quit voluntarily. And so we will impute the income you had in that job if we think it is reasonably achievable that you could go elsewhere and achieve that same income. Imagine you're a truck driver, or a school teacher, or a daycare worker, or a hairdresser, or a cook or chef, or a restaurant manager, or a salesperson in a construction supply store. So what do those folks typically make in that industry in our region? And then the imputation, the assigning of income to you if you lost the job through fault or voluntarily simply quit. These cases oftentimes will turn on vocational experts, which means people will, and we will oftentimes counsel clients based on facts, considering whether to hire employment experts to assign what someone of their skills and talents and past work experience could likely make. And you might think, well, this is common sense, Van. If they have this skill and this job background, can't I just pull up Indeed and show job listings? Well, the answer is, of course, you can, but the court will likely not take judicial notice of that, just online printouts of evidence. Sometimes I wish they would, because it would certainly be cheaper, but courts will oftentimes require experts to come in that are licensed experts that can then, with a substantial foundation and basis of expertise, opine on the reality of the pay band and types of jobs they would be eligible for and the likelihood of their employability in those pay bands. The court then takes notice of those facts and that testimony and that report, the employment expert report, and assigns or imputes income to the person who is underemployed or unemployed through fault or through lack of effort in trying to work. All of this means a tremendous amount of preparation needs to go into support cases. It is not simply you show up and raise your right hand and just say what you made last year and the court does the rest. It's far more technical and nuanced than that. I look forward to meeting with you, with me or a member of my team here at Smith Strong, to go over your support case and whether imputation of income is needed and how we get there in a secure way in court if needed. Most of our cases settle. I don't want you to think that every support case requires court. Of course, many of these cases settle before court is needed, but for about 20-25% of our support cases, court is needed, and then we need to make sure we have the right experts and evidence to be successful on that day in court. Thank you, and we look forward to meeting with you in a comprehensive case preparation meeting.